I'm Jonathan Kanter from the U.S. Department of Justice. It's great to be here today. In particular, this is my first time attending an ICN event, and I just have to say how exciting and heartwarming it's been to meet so many of you in person finally, especially after seeing you on the screens, which has been wonderful, but there's really no substitute. And I can really sense the warmth and the community just at dinner last night, today. There's just an extraordinary sense of common purpose and mission, and it really shines through. And so it's truly an honor to be here and to be with all of you. And I have so much respect for all of you and the work that you've been doing. And I look forward to humbly playing a role in that alongside my colleagues at the Department of Justice. In keeping with themes, I wanted to talk a little bit today about, from a cartel enforcement perspective, our world today in the US, and then a little bit about what I think the world will look like tomorrow. And in just a few minutes, we can only hit so much, but I think there's a lot to discuss. First of all, the challenges we're confronting today are unlike any I've seen in my lifetime in terms of the level of corporate concentration, in terms of the amount of cases and investigations that we have to confront. And that means we can't focus on a single case, a single issue, or a single industry, or a single investigation. We have to do a lot at once. And the economic realities of our time demand that, and we need to be up to the challenge. And the numbers reflect that extreme amount of work that we're doing. So just generally speaking, we have more litigation than I've ever seen at the Department of Justice. We have 6 active civil cases in litigation. That includes merger and unilateral conduct. On the criminal cartel side, we have 20 active matters in litigation. That's 20 matters before courts, including trials. And that includes 42 individuals, 8 CEOs under indictment. And so, and we ended our fiscal year 2021 with 146 pending criminal grand jury investigations, which is the most in 30 years. So it's fair to say that we are busy. We have our hands full, and we are up to the challenge, but we also recognize that we need to prioritize. And so as we are looking ahead, we are prosecuting and prioritizing cases that have the greatest impact on the daily lives of our fellow citizens. We're building out our capacity to go after international cartels, and that's something that we do alongside many of you. And we are also prosecuting wage fixing and employee allocation agreements, something that's extremely important to our mission, to protect workers from employer cartels. This is a very active area of our enforcement. We're also working tirelessly to protect public procurement. So 2 years ago, the Department of Justice introduced an initiative, the Procurement Collusion Strike Force, and leading the way, the Antitrust Division at the Department of Justice works alongside many of our governmental partners to safeguard taxpayer dollars by deterring, detecting, and prosecuting antitrust crimes. It's been an extremely effective and important initiative, one that's resulted in many innovations across our program. And in the United States, we now have a $1.2 trillion infrastructure spending project act, or Jobs Act, which will result in $1.2 trillion in spending. And the procurement implications are extraordinary. And so we are working hard to make sure that we are staying aware of any anti-competitive or collusive conduct in connection with public procurement. To do this, of course, we need to make sure that we're investing in our tools. The most important tools we have are our people, and we are growing. We are investing in our criminal and cartel program. And we're also investing in the use of data and analytics. Again, as we think about, for example, bidding in the context of public procurement, the way in which bids are analyzed and documented is becoming extraordinarily sophisticated. And it's important that we have sophisticated tools in order to assess that information and bring cases as appropriate. As Richard will discuss in a few minutes, we've made important changes to our leniency program, which creates an even greater incentive for prompt self-reporting and emphasizes individual accountability. We're dusting off our toolbox, and so what does that mean? That means we're looking at all the available tools to go get the bad guys, if you will, and an obvious example of that is Section 2 of our Sherman Act, which addresses monopolization. We've certainly increasing our efforts to address monopolization in the context of civil unilateral conduct, but it is worth observing that our Congress, since 1890, made our Section 2 of our Sherman Act criminal. It became a felony in the United States in the 70s and has been updated numerous times since. So as we work through this, we also have to recognize market realities. And so when market realities shift, so do our demands. And so one area this has become really apparent is in the area of, as a result of the COVID-19 pandemic and supply chain. So think about a world in which there are massive disruptions to our supply chain resulting from the pandemic. That could be difficulty acquiring inputs and importing products into the United States for us. It could also mean spike in demand as a result of more people being at home or lifestyle changes. That creates, along with inflation, a unique recipe, one in which many companies have been able to realize higher prices and increase margins, and increasingly passing those through to consumers. As some of those supply chain challenges naturally begin to ease, there's going to be a significant temptation for companies not to have prices go down and not to have margins shrink. So that recipe means that it creates an environment that's ripe for collusion and anti-competitive conduct. And so we announced this past February, a special initiative along with our FBI to ensure that we can find this conduct, we can address it quickly, we can address it decisively. This is also an instance where, again, international cooperation is front and center. So we are working alongside numerous partners, including many of you, to make sure that we can address these issues on a global scale. And this is something that we expect to be quite effective. So let me take a step back, and that's a real quick snapshot of our world today, but consistent with Andreas' point about tomorrow, where are we going in context of cartel enforcement in the United States? I want to highlight two areas. First is that as the challenges become more profound and the tasks become more difficult, we're going to need to invest. And that means investing, as I mentioned, in our most important resource, people. We expect that we will have to bring more cases, even than today, to courts. And to do that, we have to supplement our extraordinarily talented crew of trial lawyers and investigators. And we are hiring up a special corps of senior trial lawyers and senior litigation counsel. We are creating shared resources and infrastructure for a vibrant and state-of-the-art litigation program. And we are investing in technology to ensure that we can ingest information in large volumes and at scale and analyze that information quickly. I'd also like to talk a little bit about another piece which relates to market realities. So often in the context of civil enforcement, talk about the importance of making sure that we understand market realities, and we're adjusting not just our investigations and our litigation strategy to address market realities, but moving antitrust policy in a way that's effective. So one way to think about this is in the context of unilateral conduct. Traditionally, there's a temptation to look at unilateral conduct about a monopoly leveraging into a new market or tying. Those are certainly important matters and relevant. But in a world where we have network effects, in a world where there are positive feedback effects and data, market realities have shifted. And I talked about this a few weeks ago, but more often than not, it's competition is about, or monopolies are interested in building moats to protect them from competition, to protect them from competitive disruptions. In order to be effective in those civil enforcement cases, it's going to be necessary to understand that market reality and make sure that we can keep firms with dominance from deepening their moats, or keeping competitors or competitive threats, whether they're technology or component competitors, from engaging in conduct that would make it easier to cross over the moat or leave the moat. These kinds of market realities, often spurred by technology, are just as relevant in cartel. And so an example of this is that more and increasingly business is conducted through programmatic tools. We've seen algorithms, we've seen accessing APIs for pricing on platforms, for bidding. Increasingly, we're seeing AI becoming more important. And so just as the tools that businesses use to conduct business on a daily basis change, so too will the tools that companies use to engage in anti-competitive behavior. And so we are not far off, if at all, from a world in which AI can learn to price fix with another AI. And these are realities that we are going to have to confront. And so as enforcers, it's extremely important that we're investing in the technological expertise, the data science expertise, to understand, to detect, to investigate, ultimately to prosecute crimes. It's also going to be extremely important for companies, as they think about compliance, to start evolving. So, typically, the typical tools that you might see in the context of corporate compliance will still be relevant. For example, tip lines and training. But as firms start building algorithms, for example, that tap into a programming interface to conduct pricing, or can communicate with other aspects of an ecosystem, it may be necessary to start training your AI just like you train your employees. And as you construct these algorithms and these pricing tools and these other programmatic resources, it's just as important to have compliance on the front end, because companies will be held responsible if they're engaging in illegal conduct. And whether you use a smoke-filled room in a basement, or you're using AI and an API, it's still the same thing. It's still collusion. And we are investing in our resources to make sure that we can spot that and address it. And we encourage corporates to invest in the resources necessary to ensure compliance, so that we don't have to bring cases ultimately. So finally, I'd like to just close by acknowledging that incredible work, Elisabetta, Ricardo, and great work from the AGCM and the FNE on the ICN Cartel Working Group. As some may have heard, the DOJ will be joining you as co-chair for the upcoming year. I couldn't be happier and more delighted. As I said at the outset, this is an extraordinary community. The problems that we are confronting are global. The markets are global. And unless we're facilitating communication, collaboration, information sharing as appropriate, we're not going to effectively address these kinds of problems. And this organization has done so much to bring so many people together to have these open, frank, and effective conversations. And so I'm only 5.5 months into my tenure at the DOJ, but I feel like now that I'm here, I'm finally on board, because this is when you truly become part of the agency, is when you have the opportunity to attend the ICN. So I'd like to thank Andreas and the team for the incredible hospitality, and thank all of you for the warm welcome. Thank you.
Ladies and gentlemen, just to announce our next panel, It's been put together by the Cartels Working Group, and we will hear a lot about cartel enforcement in the next decade. It will be chaired by Ricardo Riesco from the Fiscalía Económica in Chile. Ricardo, you have the floor.
Thank you very much, Andreas. Good afternoon, everyone. Welcome to the Cartel Plenary session. Today we will be talking about anti-cartel enforcement in the next decade, including priorities and new trends looking beyond the pandemic. Let me start by saying that I'm very grateful and happy to be here. It took me 3 flight connections and 27 hours to come from Chile, but I'm very happy here, and this is all because of the great work put together by the Bundeskartellamt. Thank you for making this possible and for organizing this event. Dafür ein großes Kompliment an Andreas Mond und sein Team. Es ist eine große Ehre und Freude, hier in Berlin zu sein. And we have a fantastic panel today. We have Richard Powers, the Deputy Assistant Attorney General for Criminal Enforcement at the US Department of Justice. We have Teresa Moreira, Head of the Competition and Consumer Policies of UNCTAD. We have Teresa Matos Rosa, President of the Autorità della Concorrenza from Portugal. We have Johan Ysewyn, a partner at Covington and Burling, and who is here as an NGA for the European Commission. And we have, in an online manner, not present physically as she wanted, Elisabetta Iossa, Commissioner of the Autorità Garante della Concorrenza del Mercato from Italy. From the last ICN member survey, it is clear that there are a lot of topics of interest relating to cartel enforcement. In the sake of time, we will deal with 4 topics today: leniency, international cooperation, trends in cartel enforcement like hub-and-spoke cases, like buyer cartels, and collusive behavior in labor markets. And finally, we will talk about cartel agreements in public procurement, about big rigging. Let's start with leniency. Elisabetta, who is online, there is an ongoing debate about leniency programs, which has been at the core of our work as co-chairs at the Cartel Working Group of the ICN. Can you give us an overview of the global trends on this respect and what is happening in Italy?
Yes, of course. Hi, good afternoon, everybody. Great honor to be here as well. So, yes. So let me take advantage of being the first and be opening up this discussion by recalling some trends and sharing some thoughts. So we know that leniency programs have been around for a while. The first one was in 1978, and then we had a sharp increase in leniency program adoptions in 2000. The OECD reports that by 2020, 73% of the world population was covered by leniency program. And if we take into account that leniency programs typically take 10 years to reach maturity, then we understand why for many years we had really positive trends. However, now the trend has changed. The OECD reports that in the period 2015-2020, we have seen a reduction by 64% in leniency applications in 40 jurisdictions, with an increase only in 6. So it's time to share some thoughts and think about possible causes. Of course, one possible cause is related to the rise in private enforcement. This is very relevant for us in Italy, in Europe, thanks to the damage directive. But the evidence shows that leniency applications are declining also in countries which have not seen a rise in private enforcement, or they are declining also in countries where private enforcement has been going on for a while. So we need to look wider. And one thing we ought to notice as well is that there's been also a decline in ex officio investigations, with an average drop of 18% over the same period. And the number of cartel decisions has decreased in all but one region in the period 2015-2020. So the possible answers are different. One will be the optimistic one, that there are just fewer cartels and there is greater awareness of illegal conduct, and the compliance program are working, and that our advocacy effort is working. But as we heard also today, we don't believe this so much. We think more that instead there are more sophisticated cartels going on and more complex cases, and therefore we need to respond to this. Responding implies that we look at leniency program from a broad perspective. It's also taking into account how they interact with other tools. And I refer here to sanctions, the level of sanctions, settlements, compliance program, and for those who use it, commitments. So I'm happy to report that in the working of the ICN cartel group, we conducted a survey on trends, and 30 countries responded, and the majority of them reported that they are revising their leniency policy in order to make it stronger, in order to ensure consistency, predictability, and transparency. On top of that, further changes are taking place. There is a stronger investigative power. Many countries are adopting whistleblower anonymous tools. I'm happy to report that Italy is going in that direction as well. And they're strengthening relationship with other agencies and in the fight of cartels. So in Italy, we have some positive signs, which I'm happy to report. Recall that in Italy, we just transposed the ECN Plus directive, and therefore now immunity applicants can receive immunity from criminal sanctions. So we've seen numbers in the last few months growing. They're small numbers, so we cannot make too much inference out of it. But it's good to report some of the immunity applicants have explicitly said that receiving immunity from criminal sanctions was the reason why they will come forward. So with this positive note, I leave the floor to my colleagues with this view of really thinking, an auspicion to think really from a broad perspective to how these instruments interact.
Thank you, Elisabetta. Richard, the DOJ is the creator of leniency programs, and many countries around the world look at you when creating their leniency programs. You have recently announced some changes to your policy. Could you please tell us what those changes are and what are the reasons for making them?
Sure, happy to do that. And let me start by saying it's, of course, good to be here with everyone today. So I'll pick up where Assistant Attorney General Kanter left off, talking about our recent policy changes and the update to our publicly available frequently asked questions. I should remind everyone, I had to remind myself of this, that when we talk about leniency in the US, of course, we're talking about the immunity applicant, right? We only have one leniency applicant per conspiracy, so I'll use them interchangeably here today. And as I was listening, I was thinking about, when we talk about what makes for an effective leniency program, right? What are the cornerstones of an effective leniency program? It's, when you're thinking about updating or changing, I think it's really, in these moments, always important to go back to sort of these core principles, right? So you're talking about the credible threat of detection, you're talking about severe and significant sanctions, you're talking about transparency and predictability in the application of the policies in the program. And that last point is really what I'm going to talk about with respect to the recent policy updates. But before I do that, let me just say, in terms of the overall goal of what we were trying to do, was really we wanted to make leniency a more effective enforcement tool, and to improve accessibility to the program. And again, I think that promotes predictability and transparency. And so I'm going to jump into the policy changes, but let me start with actually what I think is important, which is what hasn't changed, right? A qualifying applicant under our system will receive complete immunity from criminal prosecution, right? So for a company, that means no felony conviction, that means no fine, that means no probation or monitor. And if you're in a heavily regulated sector, that means it's your best chance at avoiding debarment. Now, for companies that report self-report before we have information about the crime. So under Part A of our policy, their executives will also get immunity if they cooperate. So there, we're talking about no jail time, no time in federal prison. And for international cases, we're talking about not sitting in a prison somewhere exotic for months as you're awaiting for the extradition process to play out. And I bring that up because we've actually seen that play out a number of times in recent years. So then what are the key changes to our policy? Well, applicants must now promptly self-report. Previously, immunity applicants had to promptly and effectively terminate the misconduct upon discovery. So instead of promptly stopping the conduct, now you have to promptly self-report the conduct to us once it's discovered. We've also added requirements around compliance and remediation. So under the prior version, leniency applicants have always had to make best efforts to pay restitution to receive the immunity. That hasn't changed. That's still a requirement. But now the applicant has to make best efforts to improve the compliance program and to fully remediate the harm. And I think this change makes sense, right? Because I think it's important that victims of these serious crimes be made whole. And I think it's important that companies undertake the necessary steps to avoid being a recidivist. And then in terms of remediation, let me just give you a concrete example of what we could be talking about here. In no-poach cases, we may require a leniency applicant to not enforce non-compete agreements with their individual employees, right? So not enforcing the non-competes for a period of years. And we've done this several times in the last few years in cases, and the purpose is to remediate the lost worker mobility that came out of that cartel. And then finally, in addition to the factors we've always considered in assessing whether to grant a type B leniency, whether it would be unfair to others, we now consider as one of the factors an applicant's criminal history. So those are the policy changes. So let me turn to the updates to the publicly available frequently asked questions. And let me start by saying that we had several goals in updating, and it is a substantial update to the FAQs. We had several goals. Some of them were substantive, and some of them were, frankly, stylistic. In terms of style, we wanted to break the FAQs down in a way that would be easy to understand, as easy to understand as possible, especially for those who are unfamiliar with our leniency policy, right? That's part of our goal to make this accessible. We also wanted to address questions that applicants could have. And I think this will also help for other enforcement authorities out there who look to the DOJ's policy, because now we've really laid it out in detail. We think we've made it as easy as possible to understand. We added almost 50 additional frequently asked questions and answers. So a lot more information is in there now. And so let me just highlight very briefly, I think probably the most significant additions. We added additional clarity around the potential immunity for current employees of a Part B leniency applicant. And we made clear that what we will do with the employees of individual employees of a Part B applicant is we're going to do an individualized assessment. And we're going to apply the same principles that apply in all federal criminal prosecutions in the United States. The policy on this point, on this update, actually, it did not change. We've always had discretion, going back 30 years under Part B, on whether or not to cover the current employees of the applicant. And I think the key here for any prospective leniency applicant is be quick. Move quickly to self-report, because the earlier you come in, the more valuable any potential cooperation is to us, and the greater the likelihood that we may end up covering your current employees. Where we made changes that I've already covered to the policy, we've added additional FAQs to explain how those updates will operate in practice. We explain what prompt means. Spoiler alert, it means the same thing that it did before, although you now have a little bit more leeway for companies in terms of prompt self-disclosure, prompt self-reporting, to take a reasonable amount of time to do an internal investigation before reporting. We've also explained the compliance and remediation requirements. For restitution and private damages, which is something that was mentioned before, I think we've done several things. We've carried over some of the same concepts on restitution that I've already mentioned, but we added that we want to know what the plan is to pay restitution earlier in the process. And this is an area where we will work with applicants in terms of timing and how exactly this will play out. And then we also added about 10 FAQs with respect to how we view the Antitrust Criminal Penalty Enhancement and Reform Act, ACPERA, which is the statute that reduces damages for leniency applicants in the US. Over the years, we've received a number of questions about our views on ACPERA and how, what sorts of positions we would take. And so, where we haven't had the right vehicle to say that in a filing before court, what we've endeavored to do is put that into our FAQs so that applicants, plaintiffs' counsel, anybody can see what our positions likely would be. So I think when you couple the added transparency and accessibility with our increased emphasis on antitrust compliance programs, I think firms are better positioned to understand the truly immense benefits of leniency and what it will mean for them. I think it also means that they fully grasp the importance of prompt self-reporting their violation. As I said, the benefits of leniency are substantial. And I think when we make our leniency programs accessible and understandable to in-house counsel and the business community generally, leniency becomes a more powerful enforcement tool for us to use.
Thank you, Richard. Margarida, in order to promote leniency applications, the authorities have to have effective detection tools in the first instance. I understand that Portugal has taken several steps and initiatives in this regard. Could you please explain them to us and which other trends you identify in your country?
Of course, but thank you. First of all, it's a great pleasure to be here with you on stage and with everyone. And lieber Andreas, dir und dem Bundeskartellamt, vielen Dank für die Organisation dieser Konferenz. Es ist schön, dass wir alle wieder zusammen sein können. Bravo. And I want to say, first of all, that on leniency, I think it's ever more important to realize that there is a positive correlation between enforcement and leniency, and so the stronger the enforcement, the best chances we have to have leniency applications. And this may be maybe an old recipe for the next decade, as the title of our panel suggested, but it's still a valid recipe in my view. So that's the first point. The second point I'd like to make is that, yes, we've seen in the first quarter of this year 3 requests for full leniency, for full immunity from a fine, and 1 request for a reduction in fine. We've always had a number of leniency requests over time, but this is a higher trend than before. But I'd like to link it to the fact that we consider that the Portuguese Competition Authority, throughout the pandemic, that competition law was not suspended. Mm-hmm. And this was actually rather the time in which we wanted and needed to be more vigilant so that consumers and firms, which were in a more, in a particularly serious situation or fragile situation, were not let down by the competition authority. And so we continued throughout this time. In the past 24 months, we carried out about 10 done rates, which, considering the lockdown periods, is quite good in my view, in considering our resources. So competition enforcement was not suspended. We carried it out, and that's why we're seeing now still and even more leniency applications coming. Third and last point I would like to make is that, considering the priorities and trends for, I wouldn't say for the next decade, but for the coming months ahead, if not more, in our experience, there are 3 or 4 areas that rank high in the risk scale of enforcers, and that would be, first of all, public procurement, because there is a massive amount of financial aid coming to the support of our economies. And so with that amount of support, there's also a risk. And so we want to be very vigilant there. Second, there are sectors that we envisage as sectors for foreseeing possible crisis cartels, sectors that may have been severely affected by the pandemic, but on the other hand, also sectors that may have been benefited from the pandemic, and that's fine, but may have been profiteering, if I can use the term, from the pandemic and colluding during the pandemic. And we have seen the first signs of this in, for example, in health services, which is not surprising. And then the third area is no-poach and wage-fixing agreements. And the fourth, e-commerce, and I'd like to mention that because although it was already on enforcers' radar, there was a significant shift in consumers' pattern in terms of purchasing purchases, and there was a huge shift from bricks and mortar to the online channel, digital channels during the pandemic, and it seems here to stay. So I'll stop here in terms of our priorities and our risk scale.
Okay, thank you. Good news from Portugal. Johan, which is the take of the private sector on leniency programs nowadays?
So, well, first of all, very honored to be here representing the private sector. I and people like me advise companies who uncovered potential cartel issues and are considering immunity. So I am talking to the boards of these companies well before they come and see you, or not. Now, during the preparation of this panel, I was asked to be controversial but constructive. So here we go. First, why is the number of immunity applications decreasing so dramatically? We can spend the whole day debating this. Elisabetta suggested that there is a possible answer in the fact that there are less cartels. She then discarded it by saying that she doesn't believe it. I think in part it is true. I think in part your relentless efforts to bring compliance home has certainly worked in certain sectors on what I would call the more traditional cartels. However, as always, there is a more nuanced answer. When you talk to boards about immunity, there are many elements that come in play. One of the key considerations for any board is legal certainty and predictability. The more uncertainty you as authorities inject in that decision-making process, be it jurisdictional, be it around the criteria that you apply, be it around the fining calculation or private enforcement, the more complex it becomes for a board to sign off on the immunity decision. Second point, very briefly, you need to be aware of the impact of changes in your jurisdictions on the global immunity equation. I'm no expert on the US leniency policies, but I do see that the DOJ update of last month seems to have created some angst, some unrest amongst the US cartel bar. Especially in the context of global cartels, that uncertainty can have a ripple effect and influence the immunity decision more globally. Third, fully agreed with Margarida that the level of enforcement and the success of leniency programs are interlinked. I think it is fair to say that authorities have become a bit lazy and have become over-reliant on immunity applications. The European Commission has introduced a whole set of countermeasures and ex officio detection capabilities, more ex officio investigations. There is the data analysis unit. The anonymous whistleblower tool was already mentioned. Dawn raids are back. There is the e-leniency tool, which enables you to make immunity applications from the comfort of your own home. And there's obviously the debate also launched by President Mundt on protecting leniency applicants from follow-on damages claims. Some of these measures are about shaking the tree and seeing whether that could trigger leniency applications, but I would stress as leniency remains the heart of cartel enforcement, the key point remains trustworthiness of the systems and predictability. Thank you.
Thank you, Johan. Let's move to a closely related topic, which is international cooperation. Teresa, UNCTAD's Intergovernmental Group of Experts on Competition Law and Policy has convened a working group on cross-border cartels. Could you tell us some outcomes so far of this working group?
Thank you very much. Also, thank you very much for the opportunity and the invitation, especially to Andreas and the Bundeskartellamt team. It is really a pleasure to be here. You've always been a friend of UNCTAD, and I really appreciate this, and I wanted to thank you here today. Okay, so as probably several of you don't know, UNCTAD is the focal point for competition law and policy within the United Nations system, mostly because we are the guardians of the only internationally agreed instrument in this field, the UN set of principles and rules of competition that was approved by consensus by the UN General Assembly in 1980. This means to say that we have the pleasure, with our very large membership of 195 countries, several of which are present here today, of providing the largest platform, which of course is an open platform, not only to gather member states, but also international and regional organizations, networks, and different stakeholders. So let me just say, Ricardo, that international cooperation is really at the core, of course, of UNCTAD's work, as it is at the core of all UN work. We started, again, looking into this issue some years ago, and in 2018 we did a survey to update a little bit what were the obstacles to international cooperation in competition law enforcement, and of course, bearing in mind the importance of international cartels. And this identified, as you can imagine, legal obstacles that are typical of different jurisdictions, etc. I won't dwell into this, and practical obstacles. Some have also been mentioned here today, but I think this is something that will stay with us forever. Trust, in some cases for young and small, less experienced competition authorities of some developing countries, the fact that they are not really yet a part of the network, language barriers, etc. And through a number of very interesting discussions, we were able in 2020 to approve a document, a practical guidance to improve international cooperation in competition law enforcement between advanced competition authorities and less experienced competition authorities. This is entitled Guiding Policies and Procedures under Section F on International Cooperation of the UNCTAD. This is actually an achievement, of course, of member states. The Secretariat was just happy to facilitate this. And this document, as I said, seeks to facilitate international cooperation, of course, being another instrument to add to so many others that exist. At the same time, when we approved this instrument, we held a very interesting roundtable on this traditional topic of cross-border cartels. And this is really what led to the creation of the working group on cross-border cartels that has been extremely attended with over 100 participants. This is mostly a forum to facilitate exchange of information on very practical issues, so really for enforcers and even case handlers. And this has allowed not only the most advanced jurisdictions, for instance, OECD member states, of course, all of EU member states, but also a number of developing countries to really ask questions to their peers, to identify best practices. And we have organized, thanks to my team, a number of presentations and discussions of case studies, really enriching the knowledge and the discussion. So this is still, of course, ongoing. We think that the enthusiasm that this has generated, we would like to follow up, but as an intergovernmental organization, this will depend on member states' will. The Secretariat is here to facilitate. I think if we could reach to a point where, for instance, through regional cooperation and a lot of regional economic organizations of developing countries, and I want to mention especially several of them in the African continent, which are very vibrant and really active. The pooling of resources, exchange of technical information, case handlers from different jurisdictions being able to contact each other, I'm sure we would advance very much. As you can imagine, we are keen to facilitate, to bring countries, organizations, networks together in order to make sure that global cartels are effectively tackled. Thank you.
Thank you, Teresa. Richard, could you tell us a little bit more about the work that the DOJ has been doing to fight cross-border cartels?
Sure, and I think fighting cross-border cartels really starts with cooperation, right? I think cooperation is a key part of that. It builds better outcomes and drives better enforcement, and I think Assistant Attorney General Kanter talked about this, and I think I want to make sure it's clear that fighting cross-border cartels and partnering with many of you all in this room remains a top priority for the Antitrust Division. And I think, in terms of, our experiences recently, I think the pandemic brought to light, a number of challenges to fighting cross-border cartels in a really particularly acute ways. And, in practical terms, it could mean the challenges we faced bringing witnesses into the United States due to travel restrictions and trying to, figure out how to speak with them. And so, the way we've been able to work through that is through the assistance of our international partners. And, that can mean helping facilitate things like video interviews, which this may sound simple, like, oh, just setting up a video interview, but it's actually involves complicated legal questions about sovereignty and the scope of international treaties. So having the partnerships is incredibly important for these types of efforts. I think in terms of other efforts, we talked about the Procurement Collusion Strike Force earlier. We've added an international arm to the Procurement Collusion Strike Force. And so it's actually been a very successful undertaking. We brought our first cases based on misconduct internationally last year involving bid rigging for security services in Belgium. And so, that's another effort we're undertaking. And I think when talking about international cooperation, I think I'd also be remiss if I didn't take the opportunity to mention the focus, our focus on providing technical assistance to our agency partners around the world. Building, assisting agencies, other agencies to build capacity has been a top priority for our international program. I think building up the capacity of others helps all of us in the long run, and so we remain committed to that. And just to give you a sense of the statistics there, in the last fiscal year in 2021, we provided 17 programs focused on criminal cartel investigations and enforcement to a number of jurisdictions around the world. And so, we found that another benefit of these technical assistance programs, it's a great way to build relationships, but it can also lead to case generation and provide opportunities for additional cooperation. So, international cartel enforcement remains the top priority for us. We will continue to bring those cases and to work on our partnerships to facilitate that.
Thank you, Richard. And the Fiscalía is a good witness of those efforts you mentioned. Johan, many in the defense bar claim that you face several burdens in cross-border cartel investigations. What can we do to be more efficient, and what is the role of organizations like this one, like the ICN, to promote those efforts?
So on the theme of controversial but constructive, in my introduction, I talked about boards being very sensitive to the uncertainty. And one of the elements of uncertainty revolves around jurisdiction. I need to be able to guarantee the board that my immunity applications will cover all the jurisdictions where there is an enforcement risk. And currently, I can't do that. I have to tell the board, look, I cannot exclude that there are countries out there where the cartel only has a tangential link and they may decide to jump on the enforcement bandwagon. Now, from the outset, I am not saying that younger authorities should not engage in cartel enforcement. But what I am saying is, if you do that, there has to be a logic. And I, as a cartel defense lawyer, need to understand and need to be able to predict that logic. And that's where the controversial comes in. This is exactly the issue that the European Commission struggled with many years ago and has solved. There are 28, previously 29 competition authorities in Europe, 27 at the member state level, 1 at the European Commission level, each with their own immunity system, each with their own immunity requirements, and they were confronted with this problem. Who of the 28 takes jurisdiction? And to solve that uncertainty of forum, the ICN, the European Competition Network, introduced a model leniency program with the summary application system. For those of you who are not European, very briefly, it actually is a European-wide marker system. Applicants can protect their place in the queue at national level by filing very, very short summary applications with national agencies at the same time as they file the full leniency application with the Commission. If ultimately national authorities get interested, you can then supplement that application. You asked me what the ICN could do. I'm not saying that the ECN model is perfect. It certainly wouldn't work as a one-for-one blueprint for the ICN. But what it does do is offer food for thought on this particular issue, which I think stifles leniency applicants in coming forward. It is the risk of not knowing which authorities will actually jump on the bandwagon. Thank you.
Okay, thank you, Johan. Let's now move to the third topic. Many say that competition authorities are prosecuting new types of cartels nowadays. However, many of them, like hub-and-spoke cases, like signaling cases, like biocartels, have a long history in competition law. Anyway, it's impossible to deny that we are trying to enforce different types of collusion and cartel case activities. Margarida, the Portuguese authority has issued recently several decisions on hub-and-spoke cartels, and you have also put an eye on collusion in the labor markets. You also issued a guide to prevent that violation. Could you tell us a little bit more about those cases and initiatives, please?
Of course. Well, as you said, these competition law has been applied to these areas, labor markets, and others for a long time. This is not new. Sometimes the structure of the cartel is a little bit different, but we still need to look at the reality and apply competition law across all sectors. Why are labor markets important right now? And I think I'd like to start there and say that we want open and flexible labor markets right now in order to allow for the economy to adapt more easily and swiftly to the recovery. I mean, it's always important, but even more so now, I would say. And this is why it's part of our priorities. And this hopefully will support a more resilient, a more innovative, a more inclusive economy over time. So topics that lie in the advocacy areas such as barriers to professional mobility, but also on enforcement, for example, no poach and wage fixing agreements rank high for us and other competition authorities. I would say that this started even before the pandemic to be on our priorities, or at least on the list of areas that we were looking at least since 2017-18, and this gave, after a long thought process internally, gave way to the issuing of a report and a best practices guide issued to firms and professionals in this area in 2021. I would also say that what is really important here is that we want employers, and so firms, to adopt an independent and competitive behavior in labor markets, and thereby contributing, as I said, to a more innovation-friendly setting and for more opportunities for workers as well. So just to conclude on labor markets, we issued our first no-poach case just last week, and this was decided for several football clubs and the football league or the soccer league in Portugal. But we have seen and started investigating other no-poach cases, so it's definitely a key area for us. When regarding hub and spoke cases, as you know, hub and spoke is a hybrid type of arrangement. It combines both vertical and horizontal elements or aspects. Competitors exchange sensitive information, but only indirectly. They use a common trading partner, that it may be a supplier, that operates at a different level of the production or the distribution chain. But the result is typically the same, higher prices for consumers than otherwise in a competitive environment. So over the past 2 years, we have issued 6 hub and spoke decisions with fines over 500 million euro in large retail distribution. In our cases, we investigated and are still investigating a few other cases whether several supermarket chains resorted to their vertical relationships with common suppliers in order to promote horizontal price fixing. I want to say just a few, maybe a few words about the main takeaways from our experience in this area. First, that the available evidence in each given case is really crucial to understand whether one should pursue it as an RPM only or as a hub and spoke arrangement, especially between retailers. The ADC could have investigated and find these cases as pure RPM cases, but nevertheless there are several aspects such as the market structure and the vast evidence collected that indicated that the RPM framework did not capture the real nature of the interaction and the arrangement involved. And this is why we stuck to the reality of the arrangement and pursued hub and spoke cases, which may be more difficult than the simple RPM. Second, as a takeaway as well, our experience shows that this type of behavior is common in retail distribution in our jurisdiction, and it affects various consumer goods across the board. Again, in our cases, these were different types of drinks, spirits, household products, personal care products, etc., etc. And finally, although the facts that we investigated date back to the pre-pandemic period, our enforcement will hopefully be beneficial to consumers, given that the behavior is extremely harmful to all of them, especially in a crisis situation. Now, finally, just to conclude also, because I already spoke about crisis cartels, but like Jonathan said earlier, we are seeing a lot of evidence that worries us and across sectors, and we want to be active across the board. So this is why it's really important that antitrust agencies maintain high vigilance, not just now, but always, of course, but especially now, because households and firms as well are in a financially vulnerable situation still now. So I'll probably stop here.
Okay, thank you, Margarida. Richard, the DOJ has also put an eye on fighting collusion in the labor markets. Can you discuss what the DOJ has been doing and what are your expectations for the future?
Sure. So, as I think you heard earlier, prosecuting collusion in labor markets remains a top priority for us. Labor competition enforcement goes directly to the heart of the Antitrust Division's economic justice mission. And so if you'll indulge me, let me start with a sort of a brief example for everyone in the audience, right? How would you feel? How would you feel if you learned that your employer had an agreement with another prospective employer not to increase your salary during this period of high inflation? Or what if your employer agreed with other potential employers that no one could approach or recruit you, that no other firm could approach or recruit you for a job you might be qualified for, but a job you might actually want? And further, that if you went looking for another job, the first thing the business told you when you approached them was that you need to go to your employer first and tell your boss that you're looking to leave the company and get their permission. How would you feel? It's not right, right? You wouldn't feel good about it. It's not right. It's not just. And my point is really that this isn't some abstract or theoretical issue. The harm from these agreements is real. Competitive labor markets can mean the difference between saving for a home and putting a kid through college. It can mean prohibiting a worker from leaving a toxic work environment, or going to an employer that can make better use of your talents. You know, in terms of the law, naked labor market allocation and wage fixing conspiracies are indistinguishable from agreements to fix product prices or allocate markets by territory or customer. So going back a few years, in October of 2016, the Antitrust Division, together with our colleagues at the US FTC, issued guidance to educate and inform businesses and human resource professionals about how the antitrust laws apply to hiring and compensation decisions. And we also made a series of public statements moving forward that we intended to exercise our prosecutorial discretion in favor of criminal prosecution. But I think it's important to note that neither our guidance on the topic nor public statements has the power to change the law. You know, our Supreme Court held long ago that the Sherman Act applies equally to all industries across all markets, including labor markets. And so while we've only recently begun to make labor markets cartels a priority, these cases are not novel. The conduct does not fall within some sort of gray zone. Wage fixing is price fixing. No-poach agreements are employer allocation agreements. And so we have a number of ongoing investigations. We've had some recent trials, and we will learn our lessons from the trials, and we will continue to move our work forward in this area. These are serious criminal violations of the antitrust laws, and it's our job to investigate and bring prosecutions when warranted by the law and the facts of each case.
Thank you, Richard. Johan, you have argued in the past that the concept of cartel has broadened too much, or a lot, and that creates uncertainty. In general, what types of questions are you receiving from your clients?
This is one of my hobby horses. I do think that competition authorities are pushing the bucket quite a bit, and I've got a couple of examples. I mean, hub and spoke cartels is one of my favorite topics. I always say that I know the fee rates of every law firm in Brussels, all of my competitors. I know what they charge. Why? Not because they directly tell me, but my clients tell me. They come to me and they say, hey, Johan, you're really expensive. Freshfields is much cheaper. Now, then I know they lie. That's not the point. So what makes this classic negotiation technique, which is you are too expensive compared to your competitors, a cartel? We had the seminal replica kits case by the Office of Fair Trading, but the kind of criteria have moved, and authorities are now mixing it up with facilitation. There's no more structure, and I think that is a serious problem, and I'll come to that in a minute after that. Signaling through price announcements. I mean, this happens every hour, every day of the week. People publish their prices. People publish other commercial information. But when does that become a signaling device, a signaling mechanism to facilitate coordination? Again, the parameters are unclear. They're constantly moving. Purchasing cartels. What makes a pro-competitive joint purchasing arrangement into a black purchasing cartel? Is it secrecy? Is that the only thing? Again, unclear. The reason why it's such a problem is these very creative, innovative theories of harm have reduced the predictability that I was talking about for the board. So if I go to a board and I say, look, I don't have all the facts, because by definition, I don't have all the facts at the beginning of the investigation, but, you know, what about immunity? And then I have to say, well, I'm not really sure whether this is an infringement or not. I'm not really sure how authorities will assess that. I think that's a problem. In addition, picking up on one of the points that Mark van der Woude made, this has led to a process of de facto lawmaking by authorities through settlement and commitment decisions. So basically, we've reduced the rigor from the definition of the cartel concept. And I think I was heartened to hear yesterday at the IBA conference here in Berlin where Gerard Mirsch spoke, one of the DG Comp heads of unit. The Commission is now thinking of offering guidance on some of those more innovative theories of harm. I think that's really a really good idea, and this could be extremely welcome.
Thank you, Johan. Let's now move to our last topic, which is bid rigging. After the pandemic, many governments are spending a lot of money to foster economic recovery in our countries. So therefore, we may expect some activity of the authorities in relation to cartel activities in public procurement. Margarida, Portugal, like Chile, has a centralized electronic public procurement system. Does it help for bid rigging investigations? Also, I think you have now a campaign, a public campaign, an outreach campaign for different stakeholders of the public procurement system. Has that worked so far?
The short answer is yes, but let me give you a little bit of background. We always looked at public procurement as a top area for us because it's 10% of GDP on average in OECD countries. It's 20% on average as well of public spending. It could be more in some other countries. So it's certainly an area of interest to us. It's even more important now, as we said, because there's a lot of spending, public spending into different areas in order to support the recovery of our economies. So even you have one more strong reason to focus on that. Our outreach initiative started in 2016. It has been a success story for us because not only have we multiplied the number of eyes on the ground by reaching more than 3,000 people over the past few years, but we've also engaged in a significant and relevant manner and regular manner with different stakeholders on this topic. And this means engaging with people across the chain of audit of public procurement, including the Court of Auditors. That includes engaging with national procurement agencies. It means engaging at a different level with municipalities, for example. So it's something we do on a recurrent basis and will not stop. But we've given a stronger emphasis right now because of the renewed importance of public spending. You mentioned the database. We were granted access by the law, and we've made it usable for us as a competition authority in 2017 by having a direct access, direct and fettered access to the national database. It means that everything that goes through public procurement is stored in that database with different entries that allow us to apply the relevant screens, the relevant filters that allow us also to combine with different tips that we and complaints that we receive. It was really important to combine it with our outreach initiative because we make these public officials alert and more confident about the signs that are typically signs of public of bid rigging in public procurement. They may have an intuition that there's collusion going on, but we bring to them a certain assurance that these are the typical signs that they should be aware of and they should report to us. Sounds simple, but it's really important to do this work on the ground. So this has led to an improvement in the number and the quality of the reports that we receive from different public procurement agencies. This has led to an increase in the number of cases we have opened, and also, of course, at the end of the down the line to having sanctions as well applied to public procurement, which is really important as a sign to the economy and to the firms operating in this field. More importantly, having access to the national database has also allowed us to support these tips and complaints and reports that we receive from different agencies, and have allowed us to establish the more firm ground for us to obtain a mandate to search companies by being more convincing with the public prosecutor about the evidence that may support the case. So, not to mention that we've also opened a case entirely based on evidence from the database, because it's a long database. The longer the better. The longer, I mean long by 12, 13 years now, and this gives rise also to detecting the same pattern in other tenders, not just the one that was being reported to us, which is typically the case. We receive reports on a particular tender, but then by using the full database, we were able to detect the same pattern in many other tenders by the same firm. So extremely important, and I would only recommend that countries work towards that direction in order to have a national database if possible, and with access by competition authorities so that they can work fully with that data.
Thank you, Margarida. Elisabetta, let me come back to you. Can you tell us what the Italian Competition Authority is doing regarding to prevent or to detect violations in public procurement?
Sure. So fighting bid rigging in Italy remains a top priority. This is for a number of reasons, as Margarida just said. Even in Italy, the procurement is a large share, about 16% of GDP. Also, we are receiving funds from the National Resilience and Recovery Plan, and these funds will be allocated by competitive tendering. And in the Italian Competition Authority, 50% of cartel cases since 2015 have regarded bid rigging. Now, we face two main challenges when we deal with bid rigging. The first one, as an economist and I'm an academic by training, know very well, the same conduct by participants in a tender can be explained in different ways. So if I think, for example, of bidding consortia or subcontracting, which we know are often used by cartelists to share the cartel pie, then that evidence can equally be explained in many cases by simply the fact that parties to the bidding consortium or parties to the subcontracting agreement are efficiently allocating the contract among themselves. And the same can be said about division in lots. So there is a problem about the standard of proof, and this, together with the same challenge I will now mention, requires, in our view, to really operate with a number of different strategies. So the second challenge is that in many countries, in Italy this is certainly the case, there are lots of small public authorities. We have 25,000. And of course, a small public authority is not in the best position to detect a cartel. First of all, because they only see a small part of the market, their market, while a cartel may be taking place by market allocation or customer allocation. And second, detecting cartels is not their mission. I mean, they also get products and services for the citizens. So to deal with bid rigging, we really need a multi-faced, multi-dimensional strategy. I think Italy in this regard is really doing well and doing a lot. Let me briefly mention what we do. So from an ex-ante perspective, we have a lot of advocacy effort. Just in 2022, we had about 100 advocacy interventions, not all, of course, in procurement, but in the success rate is above 60%. So these are cases where we talk to the public authority, to the procurement authority, and we ask them to redesign the tender in a more pro-competitive fashion. Second, we already mentioned the ICN+ directive. It was very important for us because criminal sanctions in Italy only, cartelists are liable for criminal sanctions only in bid rigging. So providing a criminal immunity to the immunity applicant is, as I said, a powerful instrument and is already producing many effects. Third, we work a lot on interagency collaboration. So you may recall that Italy has one of the first centralized procurement authority, and what we've done in the past, and we are strengthening it over and over, is we sign memorandum of understanding with the centralized procurement authority so as to facilitate reporting and sharing of information. And this is important because it helps facing one of the challenges I mentioned, which is the fact that small authorities only see a little part of the market. A centralized authority has a better larger view and therefore is in a better position to detect the cartels. The other thing we do is we have signed a memorandum of understanding also with public procurement and in the main cities, and this allows us to have direct access to wiretaps and therefore to direct investigations more effectively. I already mentioned that we're introducing this anonymous whistleblower tool, which I'm sure will prompt further leniency applications. But there is also another thing which Italy is doing, I think, and it's one of the first countries doing this. We have introduced a legality integrity rating system certifying firms' integrity. So firms that have violated the antitrust law don't get this rating, and if they got it, they lose it. And this is very important because public authorities are now using this rating system to reward firms that have good rating with additional points in the tender. So this is a system that is different from debarment. Of course, in Italy we also have that, and is left to the discretion of public authorities for reasons we all know. This is an additional system that operates as a stick and a carrot in terms of rewarding integrity and punishing antitrust violation without using automatic debarment. So I think I can say that fighting the rigging remains a priority for the Italian Competition Authority, and we are confident that this multidimensional strategy is the way forward.
Thank you, Elisabetta. Teresa, what is of the interest of UNCTAD regarding bid rigging, especially during the pandemic? What have you seen?
Thank you very much. Well, I can say that if the share of public procurement is high in developed countries, it is higher in developing countries. According to the World Bank, low-income countries have the largest share of public procurement in GDP at 14.5%, followed by upper middle income countries at 13.6%. Of course, the COVID-19 pandemic led to a spike in public procurement. We saw government interventions in countries across the world, and so public procurement became, I would say, even more important. I think what we have seen and already heard from, at least from Margarida and from Elisabetta, really highlight what are the issues. Of course, strong law enforcement, but I would say good investment in interagency collaboration, namely with public procurement authorities. This is more challenging, especially when, as Elisabetta was saying, there is a multiplicity of public bodies spread across especially large countries that are not familiar with competition law and policy, and will not necessarily be equipped to detect cartel practices, and also advocacy, of course. So combined, I think we have heard already very good examples, and I think this is the type of best practices we could recommend. But I would like to share some examples that were identified throughout the pandemic, because I think they show that developing countries' competition authorities across the world have also been very much up to speed in understanding the importance of public procurement and in fighting bid rigging. So my first example would be something that we have been working on, which is how to support micro and small and medium-sized companies, first of all, the most seriously hit by the pandemic all over the world, but especially in developing countries, to overcome the pandemic negative impact. And so how to facilitate or encourage, in a way, their access to public procurement. We actually released earlier this year in January a report on economic recovery, especially SMEs resurgent in times of COVID-19. And this topic was followed up by El Salvador, which of course is not a very large country, but which issued a very interesting guide to establish guidelines and to improve public procurement procedures to facilitate SMEs and micro companies to also access to tenders, etc. I think this is a very good example. Another example I wanted to give is that UNCTAD has an interesting trilateral cooperation with the United Nations Regional Economic Commission devoted to the Arab world and with OECD. And because in the region you have a lot of Middle East, but also some African countries, some of which have been undergoing reforms and structural restructurations, public procurement was identified as a key issue. So together we developed an online course on public procurement that is quite well attended, of course, addressed also at other governmental officials, because the idea is really to make them familiar with this issue. And finally, two other examples. I think, well, Egypt, the Egyptian Competition Authority is participating. I'm not sure if the Indian Competition Authority is participating, but I think they both have reported to us very interesting practices that, again, go back to what has been mentioned earlier. So the Competition Commission of India, in order to make sure, of course, that public money was well spent, introduced, I believe in late 2020, the State Resource Person Scheme, where resource persons were engaged, and in each state they would train state and state-owned enterprises, procurement officials, and really equip them with the tools necessary to identify bid rigging practices. And of course, they conducted almost 90 training programs, which I think says a lot of a country that is almost a continent. And also the Egyptian Competition Authority, which reported to us that they had provided guidance on different methods to detect infringements, namely bid rigging, to the Egyptian Authority of Standardized Procurement, Supply and Medical Supplies, which was so critical during the first months of the pandemic. So again, what we heard here today, I think makes a very good case. We would be very happy to disseminate other best practices, because obviously public procurement and bid rigging will remain very important even when we are in the aftermath of the pandemic.
Thank you, Teresa. As you can see, competition authorities all over the world and organizations have been very active in enforcing our antitrust laws. We will continue to do so, despite we have huge challenges ahead of us. Please join me in thanking all of the panelists for this great discussion.